last one was actually a highly sophisticated case related to a gas pipeline that was somehow obstructed. The construction, termination of the construction was obstructed by, well, I wouldn't say by government policies, but by groups that had no interest that that gas pipeline be finished. So what looked at first sight like a social problem with the locals that imposed a series of legal actions, it then turned out that it was a bit much worse than that. It wasn't social interest, it was actually criminal groups trying to obstruct the construction of that gas pipeline. And that, of course, was a fact, so there was no way how to finish the gas pipeline, so we had to solve the issue of damages, which was then highly sophisticated. As you can imagine, there was a state agency involved, so it's not something you take easy. Even without the state agency, you wouldn't take it easy. And it took us quite a while to find the way through the jungle of causality, which is the key issue in any damages claim. And fortunately, the arbitral tribunal, I was the president, we came up that we should have an additional round of a joint expert opinion by both experts, very renowned experts, and they delivered a joint document, of course, indicating where they did not agree, and that was the document that actually helped us solve the issue. And it was quite interesting because that turned out, when we were already far along the drafting of the arbitral award, we figured out, well, we got some input information in the joint expert report that actually solves us one of the key questions, which at the time of the hearing we were not that aware, because we were not that aware that there would be causality issues of such a sophistication. And we're happy that it turned out we rendered the award with some time. It took us quite some time to word the award very carefully. And then later on, we learned from the news that the award was paid, substantial award in the 9-digit range, that the award was paid within 3 months. And that was already good news because, well, it's an arbitral tribunal in a case where there are elements that are not the typical elements. You're always afraid that nobody likes that, so someone goes for annulment. But it didn't happen, it was actually paid. And the arbitral tribunal actually considered that as damages were paid, the gas pipeline should be delivered to the state entity. But we found out we didn't have competence to do that, so we couldn't rule on that. And quite recently, 3 months ago, we again learned from the news that the company that was awarded the damages delivered the gas pipeline to the state entity without further cost. So we were like, wow, that's what we thought should be done. We couldn't order it, it was outside of our scope. But it was done, and we think it was quite a lengthy but very successful arbitration. Scene, Mexico and Latin America, I think it's about more than 30% of, for example, ICC arbitrations. In Mexico, LCA has been handling some of the largest arbitrations in the last couple of years, and the same with ICDR. So it is a venue with competing arbitral institutions. It's a huge market. I think more than 30% of all arbitrations of the ICC, large arbitrations, are located in Latin America, so it is a market where you have to be. And in order to be, you have to speak Spanish. That's the first thing. So we usually have large arbitrations in Spanish in the region. That has an advantage if you speak Spanish, of course, as arbitrator. Maybe a disadvantage with respect to the pool of arbitrators. So you have to know very well who are arbitrators that are first independent, impartial, ethical. As everywhere in the world, there is a tendency to form groups, and that tendency is somehow also fomented by the large arbitral institutions. And that sometimes means that arbitrators have perhaps too close contact to the colleagues, and that may interfere in their independence and impartiality. And when you, of course, reduce the pool of potential arbitrators to Spanish speakers, you have to know very well who are the ones who, well, they speak Spanish, but they're completely impartial, independent, they're of a different sort, they wouldn't care who is party counsel, who is not, who are the co-arbitrators, they can live with that. So you have to be very careful when you choose your arbitrator or when the president is being chosen, that they have somebody beyond local groups that might somehow interfere in the matter of impartiality, independence. And I'm sure that's not something typical for Latin America, you see it everywhere else, but it's something you have to take into consideration. In particular, as in Latin America, there is a tendency that arbitrations be held in Spanish. Well, first of all, if you look at our background, we didn't start with arbitration. Yeah? We know nowadays, unfortunately, young people, they get seduced by the topic. I mean, we all got seduced because, don't forget, arbitration is the only legal subject matter that lets you practice everywhere in the world. Yeah? I mean, we are basically commuting between Mexico, Vienna, we have an office in Washington, D.C. We couldn't do that if we did, I don't know, infrastructure projects or local law. Yeah? So the only subject matter in the world in law is arbitration, where you really can move around. Yeah? And that, of course, is very seductive and tempting. But what you actually have to do, and what we did is we started in the 90s first with foreign trade, anti-dumping. Then we went into corporate, Mexican crisis, 94, 95. 96, we had our first infrastructure project, Central Anahuac, for example, thermoelectric power plant. 99, we were in Chicosen 1, the hydropower plant. We were the council of the largest Austrian industrial conglomerate that was then sold to Siemens in 2005. And from 96 onwards, we started with arbitration. But in parallel with a very sound and solid infrastructure, M&A, corporate practice. So we first drafted the infrastructure and energy contracts before we were party counsel or I was arbitrator in those cases. And that's what gives us this solidity in these cases. I mean, we know how the contractual clauses work because we have drafted them. We're not just sitting by chance as arbitrator or party counsel. In these cases, we did these projects. We were in international public tenders, and we're still doing it today. Right now, we are attending one of the largest infrastructure projects in Mexico. So we still do that because it's important. You have to be up to date with that matters. And then we did something else, and thanks to my partner, Adriana Salomon, who comes from the field of banking, corporate banking, financial engineering, with a large banking career, but also being a lawyer. We figured out, well, the hottest topic in the world is damages. Because even by that time, there was Markante, the first book of Irmgard Mabo came out, but that was only for investment arbitration. We figured out, well, we have this expertise in projects, we have financial expertise, and we have this sophistication in law, especially comparative law. Yeah? I mean, I started in Austria, then went to England, then worked in Brussels at the EC Commission, then came to Mexico, became a lawyer in Mexico. So we thought, well, we have this overview, nobody has. So finally we ended up in Washington, D.C., myself as a visiting scholar at Georgetown University, and Adriana Salomon and I wrote a whole book for Oxford University Press on damages. So we added to our knowledge of and experience in infrastructure projects the whole damages part, and then of course the whole thing took off. So from 2014 onwards, we just climbed up the case number, not the case numbers, actually the size of the cases we were attending. Other than I had a multi-million dollar damages case for Pemex as expert, not as party counsel, as expert. So we got all these mixed experience as damages expert, party counsel, and then of course as arbitrator. And once you know these cases and once you know damages, you know what questions to ask. And still we think the grey hole up to date is damages. I mean, we organize advanced seminars on damages and that frequently with international institutions. And all that together, I think, gives us a very high comparative advantage above other arbitrators, other party counsel, and also damages experts. We tell the financial experts what they have to do, actually. Well, the first thing is, as I mentioned at the beginning, it's very tempting to rush into arbitration. Yeah? Young people work for 1 or 2 years in litigation, then they see, wow, the sexy thing is arbitration, and they want to push in. Yeah? What we advise and what we do with our people here, first we let them work for quite some years in corporate infrastructure projects, international contracts, CISG, just get the experience, become a good lawyer. And I would say you should have at least 2 or 3 specialties in law before you enter into arbitration. Don't forget, arbitration is procedural rules, that's it, not more or less. You take a course, buy some nice books, and then you know it. But if you don't know law, if you don't know how contracts work, especially long-term contracts, if you want to go in the big projects, you have to know about these BOT contracts, public-private partnerships, complex franchises, and all that stuff. If you don't know how they work, yeah, you can know about the procedure, but you won't be a good arbitrator, you won't be a good party counsel. Yeah. And that's the most important thing. So first become a good lawyer, and once you're a seasoned lawyer, you slowly get into arbitration. Don't do it at the very beginning. If you do it at the very beginning, you will end up with the sophistication of procedural tricks, how do they call it, guerrilla tactics and all that stuff. We all know that, we're all facing these things. It's a huge waste of time, especially lawyers coming from the litigation side using tactics which eat up half of the hours you invest in an arbitration. They never got to the point of what's the whole thing about. It's a waste of time. So what we need is people who come from their respective specialization areas, then get into arbitration and get the thing solved on a legal ground, not on the procedural ground, and less on procedural tactical grounds, which are quite sophisticated. I think the last book that just came out was again about advocacy. It's not advocacy, it's about knowing the law, applying the law, and the rest, of course, you have to convince the arbitral tribunal, but you don't convince them without having a case. First you have a good case, construct a good case, and then you convince. And that's what young lawyers have to know. And with respect to damages, well, there is our book on the market, so I suggest anybody to read it. It's heavily cited. It's called Damages in International Arbitration Under Complex Long-Term Contracts, published by Oxford University Press in 2014. Adriana Sanderman and I rewrote it. One chapter was written by Professor Pablo Spiller, one of the big shots, big experts in damages, and Saliano Telepiani. So we buy that, and we wrote some book chapters thereafter. We're still writing it. Actually, we're going to have one published by Kluber this year on damages in Mexico. There was a big change. And what we're also doing from time to time, we give today advanced seminars on damages in international arbitration. The last one I think we did with ICC Costa Rica. Before that we did one with the Washington DC Bar Association. We did one with ICC Austria. We do a short version, one also with Stanford University. So from time to time, when there's interest, we're organizing these advanced seminars, which have a comparative law approach and also, of course, tax law investment arbitration. Well, our goals for practice is increase our role in investment arbitration, where we were very experienced. We have one of the top teams. I started actually with a doctorate in public international and international economic law. We have had some nice cases such as René Lévy against Peru, where we participated, where we were leading the annulment procedures. We have had some others. In Mexico, we're always on the fringe to that. Mexican government policy has been very interesting and very provoking with respect to investment arbitration, so it's a matter of time until they commence. So we would increase in that area, and of course, slowly but slowly, we will shift more being arbitrator, less party counsel. I have to admit, party counsel work, we are having very complex cases. The last one with 36 mathematical formulas. Right now we're in a very complex construction case against one of the largest energy companies, and these cases are very time consuming. I would say, whereas normally you would work 2 months on a submission, you usually work 4 to 6 months on the submission, and that without having a break. So we'll certainly shift next couple of years more than being arbitrator, less party counsel work, also because of conflict of interest. Somehow we are competing with very large law firms, and they want you to decide, your party counsel, or you'd rather act as arbitrator, but don't compete with your own clients. That's you have to take care of.